Good morning. I want to welcome everybody to another weekly episode of NOMBERG Law Live. And as we do each week, we try to bring topics with interesting people in their areas of expertise. And we're keeping it in-house this week, and we've got attorney John Davis with us. Good morning, John. Thank you for having a few minutes to talk.
Good morning.
What we're talking about today, guys, is an area of law that our office practices. John specifically has many years of experience handling Social Security disability claims. Like us all, we're dealing with the pandemic, so we've had to change as the administration has made changes. And I know it's presented some challenges to the practice, and we're going to talk about some of these things. We're going to talk about how the administration has changed some of its policies and procedures, but by and large, most of it has remained the same. You have to prove or show to the administration that you meet the qualifications of being disabled. And John, let's just start with where we are now, as opposed to trying to backtrack over the last 5 months or so. Are claims still being processed? Are hearings still being conducted?
Everything is proceeding as normal, except that the Social Security offices are not open. So everything is being conducted over the telephone or through the mail or over the internet. And if you have a claim, you have to call Social Security, and it's sometimes a longer process, but it's not as convenient necessarily as going into an office. Some people may not be able to process that doing everything by the telephone or by the internet, but that's where we are right now, and it's proceeding fairly well. It's not the best, but all hearings are by telephone. And this is just basically a step away from where we were before, which was video hearings. So very few hearings are held in person anymore. And with video hearings, we were sitting in a room looking at a TV screen with a camera on top of it. And now we're having hearings entirely by telephone. So Social Security will call me, and they will call the client, the claimant, and we will hear the judge on the telephone and conduct the hearing. And it's been going quite well, actually. I know sometimes the client is a little apprehensive that they don't have the attorney sitting next to them to guide them or ask them questions, but we try to prep them well in advance by showing them videos and talking to them about the process. So everything's going quite well.
Well, now that some of I don't know if the right term is the dust has settled, but at least people are getting used to having to deal with things in life as a whole differently, and this specifically. John, when someone wants to start the process, traditionally they've had three options. They could go in person on an appointment to the administration to start the process. And when I say the process, applying for Social Security disability benefits. Or they could have a telephone interview, or they could start the process online. Are they still able to do the online process as well as the phone interview? Is that still available to people?
Yeah, no, what I am doing is, if we're contacted by someone who is interested in filing, I'd like to talk to them first and see if they are a good candidate. And if so, then I send them a package to complete, and it asks them about their medical treatment, their job history. It asks them some of the specific questions which seem a little bit odd when you go online and Social Security wants to know. But I try to get all the information I can up front from them. And then when they send that back, I call them and we go online together. I go online and start the initial application process. And I like to have that client on the line with me, because as many times as I've done this, I still see questions pop up that I've never seen before. And sometimes it's because Social Security wants some very specific information about that particular person. It always, not every time, but occasionally it will surprise me what they want. So I like to have that client on the telephone with me. But yes, we can proceed online and get that application filed and without any problem. It does take about an hour or more sometimes to do that, though. So we have to go ahead and set that time aside.
So that's the client needs to understand they're going to have some patience with the process, some patience with you, and they need to be organized. John, when they are talking with you and providing the information that you need to help start either their initial application or their appeal, what type of information do they need to have handy, available to them and eventually to you to help you do your job to help them?
Yeah, number one, medical treatment. Who have you seen? When did you see them? What kind of treatment did you get? What's the address? What's the telephone number? So all that is very important, because Social Security uses that information then to order medical records. And medical records are the basis for the whole application for disability. Without medical records, you're not going to get benefits.
So being organized really helps you as well, having that list of all of those important doctors and their contact information. What other information do they need to be able to provide to you that may be of help for you?
Well, the job history. What jobs have you held in the last 15 years? What's the name of the employer? When did you work there? That's important. Starting and stopping date. What did you do there? What was your job title? What kind of work was it? Did you do physical labor? How much weight did you lift on a regular basis? How many hours were you standing? How many hours were you sitting? And what kind of training did you have? Did you have specialized training in order to do that job? So those are very important questions.
One of the things that I've noticed in handling these cases, that oftentimes our clients may be used to the process of litigation. Say an automobile accident, you have one driver against another driver or against an insurance company, and it's, plaintiff and defendant. Ultimately, there'll be somebody to make a decision on who is at fault or liable in that case. But it's different in Social Security, and there's not really another side to it, so to speak. And if you would, just in your experience, how do you explain to your clients what this process is about? What's the purpose of either on the DDS level, the local state level, or on the ALJ level? What are we trying to prove here?
Well, number one is that you can't hold any job in the national economy 8 hours a day, 40 hours a week, not miss more than 2 or 3 days a month because of absences. But for most people, it's the inability to hold a sedentary job. And I tell my clients all the time, a person in a wheelchair can do a sedentary job as long as they can lift 10 pounds once an hour. So it's not, but that's not the only thing that we look at, because a lot of cases are pain cases, which, back cases, joint cases. And if pain is the problem, that's not a physical limitation that Social Security recognizes, but it's a mental limitation. So there are other things other than just being able to sit, stand, and walk to look at. But it is not supposed to be an adversarial kind of situation. You know, it's supposed to be about getting to the truth. And you mentioned DDS, which is the Alabama Department of Disability Services. They are not part of Social Security, but they make the first two decisions in your application. They have no incentive to put you on benefits. They have every incentive to deny you benefits. So most applications are denied at those first two stages. And then we ask for a hearing before an administrative law judge. The law judge is part of Social Security, but they're supposed to be objective and non-partial. But of course, they're human beings and they bring their own prejudices to the hearings. And sometimes hearings can be adversarial with the judge, but most judges are very fair, don't have problems with most judges. And it's a matter of getting those medical records into the Social Security file and having that claimant testify about their limitations. And it's very important during this whole process, even before you get started, that when you go to the doctor, you talk about all of your symptoms. Mm-hmm. You know, we usually have that squeaky wheel syndrome. Well, I've got a cold and that's all they talk about, but they forget to talk about the fact that yesterday they could hardly get out of bed because their back hurt so bad. Mm-hmm. So it's very important every time you go to the doctor, any doctor, tell them about all of your symptoms that you've been experiencing since the last time you saw a doctor.
Well, John, let's talk about those challenges right now. In the last few months, many doctors' offices and clinics actually have shut down to the public. Thankfully, in the last few weeks, I've noticed, at least locally, doctors' offices are having patients come back. They've now put safety protocols in place, but you still have patients, you still have individuals who are not getting out of their homes because they have underlying health conditions, or they're just afraid right now to get out to go into public places. Many doctors' offices have put into place telemedicine and other methods, other ways to still be treated and evaluated. And what are some of your thoughts about how can a claimant still be consistent with their claim and still be treated even if they have these hurdles in place?
Yeah, we talked about the patient portals earlier, and I'm kind of new to the patient portal myself, but you can actually go on there and report symptoms, and hopefully that gets into the medical record. But the other thing that you can do, and this is what I suggest to a lot of my clients, is keep a diary or a log. Mm-hmm. You can use a spiral notebook, and just, you don't need to do it every day, but when you have a bad day or an incident of note, make a note of that, the date, what it was, what happened, how long it lasted. And I submit those as evidence. It becomes part of the record, and it helps to substantiate your credibility when you testify at that hearing, because you've made those notes yourself, and regarding what's happened to you. Now, hopefully we'll get past this COVID pandemic, and we'll be able to get back to doctors and face to face. I know the last time I was at the doctor about a week ago, the doctor was wearing a face shield and was keeping his distance from me for the most part. So hopefully we'll get past that very quickly.
John, you mentioned credibility, and for our practice, whether it's a workers' comp case or a personal injury case or Social Security matter, credibility is important in the eyes of the decision maker. In your experience, what do the administrative law judges, how do they measure credibility, and why is it important to them for the client or the claimant to be a credible person in their claim?
Yeah, well, the medical records don't always tell the full story, and that's why we have these hearings. Judges like to eyeball clients and observe them. Unfortunately, we can't do that right now. But that's why it's so important to talk about your symptoms when you're at the doctor. Now, a lot of times I hear people say, well, I talked to the nurse or I talked to the receptionist and it never showed up in the medical record. So it's really important that I can't harp on that enough. Tell everybody everything every time. Tell the nurse, tell the receptionist, tell the doctor. Make sure they understand and that what your symptoms are, because when those symptoms are in the medical record, they help to substantiate your credibility. Whether the judge looks at the medical records and he says, well, you didn't mention anything about this. You saw the doctor 5 times and you never said a word about it. Or if you had a problem with this, why didn't you seek treatment? You went to the doctor, but you never got treatment. So that's the most important thing that I see as far as credibility, is getting that in the medical record.
Guys, we're talking with attorney John Davis, and what we're specifically talking about is how Social Security disability claims are being handled during the pandemic. And earlier we touched on how hearings are being conducted. And John, it's a whole new world having to do strictly telephone hearings. There are challenges to having those hearings. The judge doesn't get to see the client or the claimant in person. They can't see or observe their mannerisms. The client and the attorney or representative are not in the same space. So it can be a little scary sometimes for someone who's home and on the phone with a judge who they may consider to be very important and not used to being on these conference calls. And how do you advise your clients how to handle these types of hearings that can last 10 minutes or they can go for an hour or more?
Yeah. Well, one of the things I tell them is, if you've got a problem with a question, and if you need to talk to me, just say, I need a break. And the hearing can be stopped, and we can talk privately on the telephone, just like we would at a normal hearing. If it was taking place, we were physically in the room with the judge, we can just say, Judge, we need a break. Can we go off the record, and we'll come back in 10 minutes? And they're going to allow that. I haven't done that yet. I haven't encountered that yet on a telephone hearing, but a lot of people are more afraid to be in that room with a judge than they are so far. What I've seen so far is that then they're more at ease on the telephone than they are actually in person in front of a judge. So I think that the anxiety level, though, is always high with a client when at these hearings. A lot's on the line, and that's one of the reasons I like to talk to them. I like to talk to, or I like to actually sit down and talk to clients, but I talked to them on the telephone here recently. I like to talk to them at least 2 or 3 times before a hearing. I try to take them through the process of the hearing, so that they're familiar with what's going on. They don't get surprised by anything, and put them at ease so that they know what to expect. But there's some of these judges sometimes come up with some questions that might take you off guard and take you by surprise. So, but it's always possible to stop that hearing and get back to it later.
Well, that's good to know. And John, we're getting close to the end of our discussion, and I appreciate your expertise and sharing your experiences about this. If you have somebody who's interested in pursuing benefits, or they've already been through the first level and they now want to appeal, but they've got concerns about meeting with an attorney in person, how are we handling signing up clients and communicating with them and getting the process started if we don't meet with them in person?
Yeah, now a lot of times we get contacted by email, and I communicate with them by email. But if you know, if they want to talk, we can talk to them over the phone. It's, and, you know, and if necessary, if they really want to sit down with us, with me, we can arrange that. We're not promoting that, but if absolutely necessary, we can do that. But mostly we're doing it over the telephone, over the internet, and through the mail. There's a lot of information that we need in order to file that initial application. So what I do is I send them a package in the mail. There are various forms required by Social Security and lots of information that's required. And that can take, I mean, if I got that package in the mail and wasn't familiar with it, it's a little daunting. So it takes a little while to complete all that. You're not going to have all that information necessarily. And the other thing that they can do is you can create a My account, MY account at SSA.gov, and you can see your earnings record there. And that's important. Not only can you see your earnings record, what's been reported to Social Security, but also see what your disability benefit is going to be, and which is very helpful. And it has your family allowance too. So if you have children, it's important that we tell Social Security about those children if they're under the age of 19 and unmarried and going to school. They can get a benefit too. And you can see what that family benefit is. It's usually 20 or 30% greater than the individual benefit. So create your My account.
That's all great advice. And lastly, John, what kind of deadlines does the Social Security Administration impose for when you want to appeal? Let's say you've lost on the first level. You don't have an extended period of time. You have a definitive time, which you've got to get certain things done. Could you share some of those deadlines and why those are important?
Yeah, there's one deadline, 60 days, plus 5 days for mailing. So 65 days, but don't push it. Yeah, you don't want to wait more than the 60 days in order to do something. So please contact us as soon as you get to the denial letter. Don't wait, because again, sometimes we'll need information. We'll need to talk to you, and it's hard. It's not always easy to get an appeal filed within a day or so. So don't wait till the end of the 60 days. But all of the appeal deadlines within the first 4 levels are 60 days.
John, one thing I just remembered I wanted to make sure that I asked is, historically, depending on the judge and the judge's caseload, will determine how quickly decisions are issued, whether it's favorable or unfavorable, or the judge needs more medical evidence. That all could be weeks or it could be months, just depending on, and this is pre-pandemic. What are you seeing right now by way of timetables on decisions being made? Are they any faster? Are they slower? Again, I know it depends on the judge, but what are you seeing these days?
We're getting some decisions within a week, and I have some decisions that have been pending for 6 months. So, it's hard to say, and I think that's fairly normal. That really hasn't changed. Mm-hmm. Judges used to be able to do what was called a bench decision, where they could make a decision right at the hearing. At the end of the hearing, they could go ahead, and it was going to be a fully favorable decision, typically. But if they're going to deny you, then that usually takes longer. Sadly, you have to wait 6 months sometimes to get an unfavorable decision.
Just to be denied, yeah.
Yeah.
Well, John, thank you for sharing your experience and expertise of what's going on with Social Security cases. For those of you who are interested in the process or want to talk with John or our office about these type matters, we've got a couple of ways to do so. We also have a couple of resources. You can call our office at 205-930-6900 to start that process. We also have a very active YouTube channel, NOMBERG Law Firm. We have literally hundreds of videos on that channel, many of which are dedicated to Social Security disability matters. So thank you, John, for your time and sharing again with what you're seeing these days with this process.
Yeah, thank you.
Well, guys, that'll conclude us for today. As we do each week, interesting conversations with people and their expertise. And John certainly fits that bill in the Social Security disability matters. Very knowledgeable, and just give him a call. I hope you have a safe week, and we will catch you again next Tuesday at 10 a.m. Central. Y'all have a good week.